God.
So what I'm going to do, just because there are so many cases and we want to get through them so that we can do the hypothetical on Tuesday, let's, I'll just go around the room and somebody tell me about the case, and we'll get through them all today. So we start with the Eleanor, custody of Eleanor case. Whoever wants to start can start.
You know.
John? Okay, go ahead.
All right, Eleanor and Carol were in need of care and protection. Judge placed him in custody of DSS, and it was reversed here. The mother's boyfriend allegedly touched the daughters down there. Eleanor had a vaginal infection, which led to the discovery of the abuse. The mother was really blind to the boyfriend's abuse. If not blind, she was just refused to believe it, I guess is what they were saying. And DSS filed statutory protection petition for both girls under MGL 119, subsection 24 and 26. Flanders, the boyfriend, suffered from mental illness, repeated psychological admissions. The issue is whether the mother was unfit, and the holding was yes, she was. There was clear and convincing evidence to show that she was either blind to it or so ignorant to it that she was unfit, and it was reversed to the juvenile court.
Okay, here's a question. What did the SJC say about what the standard of review should be relative to when they, review a care and protection finding from the juvenile court?
They required a clear and convincing evidence.
Well, remember, clear and convincing evidence is the proof at trial, right? So DCF has to, in order for the juvenile court judge to adjudicate the children in need of care and protection, DCF has to show parents are currently unfit. But now you have a case like Eleanor that ended up going to the SJC. And so for the SJC to reverse that finding, that's what I'm asking about when I say what's the standard of review. We're talking now about an appellate court. How does an appellate court review, custody appeals like Eleanor? And there's language in the case about that. That's why I'm pointing it out.
The appellate review needs to determine whether the judge's findings were
clearly erroneous.
Clearly erroneous,
yeah.
whether they proved parental unfitness by clear
exactly.
evidence.
And then the SJC further goes on and says that a finding is clearly erroneous when there's no evidence to support it, or when, although there's evidence to support it, the reviewing court, meaning the SJC, right, on the entire evidence is left with the definite and firm conviction that a mistake has been committed. So obviously, as John said, the SJC found that that was not the case here. So Eleanor is cited quite often, for that proposition with the standard of review for an appellate court to determine whether the CNP finding was erroneous. Another doctrine that's talked about in the case, John, you mentioned Flanders, the mother's husband. What did the SJC say about the evidence regarding Flanders?
You're talking about like his mental illness and instability in psychiatric admissions?
Profile evidence. Anybody know what profile evidence is? Has anyone taken evidence?
I have, but I don't know.
I have.
But you don't remember?
Yeah.
Okay.
I actually don't think I heard it.
So, Flanders was the abuser, correct?
Yep.
Mm-hmm.
And the mom was not. Notice that the court says something about the judge's reliance on profile evidence, that Flanders demonstrated characteristics associated with child sexual offenders. Even if you don't have evidence, what do you think is wrong about that? Should a judge and a jury, because in some of the, actually this was a CMP case, never mind, but if it was the criminal sexual abuse case, you might have a jury as well. But should a court be able to hear evidence that someone demonstrates the characteristics of an abuser versus, so that's profile evidence versus, we talked about with the context of domestic violence, the battered woman syndrome or the battered child syndrome, which an expert may testify, about what that syndrome is, correct? This is different. Profile, just think of the word profile. So what might be wrong about a judge hearing that?
That with the battered woman, or an abused child, they display things, possible characteristics of what has potentially happened to them, where profile is saying, you may not have done it. It's really a tenuous thread, I think, that you may have characteristics that are of that profile, but you may not have ever done anything.
Anybody else?
Didn't they say that the profile evidence it satisfied the clear and convincing evidentiary standard, but it might not mesh well, because you're profiling someone. So I don't know. It's
profile evidence is inadmissible.
It's inadmissible.
Inadmissible. Think of the reasons why it might be inadmissible. So again, I'll read you that if the proffered evidence is going to be that the defendant here demonstrates characteristics associated with child abuse offenders, what's wrong with that? Yeah.
It sets him up for people to automatically assume he's guilty.
Yeah, and what's the one word that's wrong about it? Prejudicial.
Yeah.
Prejudicial. So profile evidence, and profiles usually, it's the defendant who, in this case, it was the CMP case. Profile evidence doctrine, comes out of criminal law, obviously. But remember that this is a sexual abuse case that subjected the parents not only to loss of custody within the context of the CMP case, but also perhaps to criminal prosecution as well. So that's another thing that's important about the custody of Eleanor's case. The SJC also defines somewhere in here what clear and convincing, a nice little definition of clear and convincing. Anybody know where it is? Clear and convincing proof involves a degree of belief greater than preponderance, but less than beyond a reasonable doubt. So it's somewhere in the middle of the two. So that's Eleanor. Who wants to do the Carlos case?
Did she say less than reasonable?
I don't know who I said, but I don't care. Laura or Nicole.
So adoption of Carlos, in the trial court, DCF was denied the consent to adoption. The appeals reversed it and was allowing the adoption, and the SJC affirmed the trial court, which was to deny the adoption. And Carlos was born out of wedlock, but his father died without him ever having shown an interest in Carlos. The mother married another man, and who Carlos accepted as his father. And then there was another child born when Carlos was 3. So Carlos was staying with his grandparents, and he disclosed to them that his stepfather had sexually abused him. And what came out of the case was that the mother, continued to support the father, but they defined the unfitness standard for permanent custody or adoption, which was clear and convincing evidence that a parent's unfit to
Can you
further.
come back to your point when you said the mother supported the father? What did the SGC say about what was the holding relative to future parental fitness? This case went to, by the way, this case had gone through a few appellate routes. The case that you're reading is the case that finally went to the SJC.
The judge can, one of the things is the judge can consider whether the unfitness is temporary or not.
What was mother's? What was mother's position? At time of trial versus years later. Do you know what I'm saying, Nicole?
Wasn't she kind of in denial about her child being sexually abused, and then later on she said that she would be willing to cooperate as long as the term sexual abuse was not used?
So yeah, she started to take, sort of like little baby steps toward acknowledgement, whereas in the beginning she was in denial. Okay, continue, Laura.
Sorry, I don't know where I left, but the unfitness standard for permanent custody or adoption was clear and convincing evidence that a parent's unfit to further the child's best interest. But fitness and best interests are interrelated, and what the judge needs to balance is the parent's character, temperament, capacity, conduct in relation to the child's needs, age, affection, and environment. And in line with what Nicole said, the judge can consider whether the unfitness is temporary or was she making progress.
So the judge can consider possible consideration of future parental fitness can be appropriate.
Mm-hmm.
So this case is also important, and I think you honed in on it a little bit, but let me make it clearer. The difference between, even though it's called the adoption of Carlos, it became a termination case, but it started off as a DSF at the time, petitioning for care and protection of Carlos, and ultimately, DCF, the agency changes its sole termination. But the court goes in its rationale discusses the difference between a care and protection trial, a care and protection case, and a 210, an adoption case. And how is it different in terms of parental rights? Laura?
Yeah, that just...
So let me let's take it by steps. A care and protection case, when it goes to trial, what is it that the judge is trying to determine? What's the issue at trial in a care and protection case? Let's even if Laura has it, if not, let Nicole have her hand up.
Current unfitness.
Current unfitness, okay. What's the issue in a termination, in an adoption? Let's free these kids up for adoption because parents unfit. What's the issue what's the issue in the termination trial?
Current and future unfitness.
No. Why do I say no so emphatically?
Because it gets...
We just said that the issue to lose custody in a care and protection case is current parental unfitness, right? So what's the difference if you're saying that that's the same issue in termination? Shouldn't the issue in termination be a little bit different? And what's the little bit? Or maybe a lot different?
The best interest of the child.
Exactly. So it's still unfitness, but it's in the context of best interest, isn't it?
Yes.
And the court talks about that. This is a good case to sort of, look at the interrelationship of these two cases, where one is, they're both extreme, because in a care protection case you're losing, custody of your child, but in termination cases, extreme to the nth degree, because you now have lost parental rights. And what the SJC is saying is, before you go that route, you've got to exhaust everything. You've got to make sure that it is in the best interest of this child, these children, to dispense with the parent's consent to adoption because the parents are unfit. That's the thing. It's very hard to kind of separate those two altogether. An early SJC case uses this language, says that the best interest test and the fitness test, are not separate and distinct, but cognate and connected. So they are connected, but whenever you hear dispense with consent to adoption, or Chapter 210, terminate parental rights, it's still clear and convincing evidence, but it's clear and convincing evidence that it's in the best interest of this child, of these children, to be released for adoption because parents are unfit. So it's kind of the two together, whereas, and the focus becomes more best interest, sort of, for termination, and more on current parental fitness for the care and protection trial. Because you can be unfit at the time of care and protection trial, and, I don't know, 6 months later, a year later, you might not be unfit anymore. And that's the whole purpose of the reviews, right, in the care and protection cases. You can come back. The court holds annual reviews, even if you don't, petition for determination as well. Who wants to do custody of Jennifer? Okay, Amanda?
So this was a case where the father was sexually abusing his daughters, but he had a prior record for indecent assault and battery on a child. And the issue here was the admitted testimony from the teachers, social workers, psychologists, and other statements made by the daughters. It was concerning the state of mind. They were trying to assert the state of mind exception under the hearsay rule, trying to say that it shouldn't be allowed in as evidence. And the judge relied substantially on prior evidence on the past conviction in order to convict him on this.
So let's take this apart, because you're talking about 2 points that actually were separate sort of pieces of evidence, right?
Yep.
So let's talk about his guilty plea to indecent assault and battery of a child under 18. So that was admitted as at trial, right?
Correct.
Admissible or not?
Admissible.
Okay, and why is
At
it?
trial.
Yeah, and so it's admissible because why? I'm sorry, how is it relevant to being?
Not really sure.
Okay, was his guilty plea in re custody of Jennifer dealt with his kids, correct?
Correct.
Or kid, I forgot. Is it just Jennifer?
It
or
says
was there
abused
another
his
child?
daughters.
Okay.
Plural.
All right. Was the guilty plea, Jennifer, on a different child or his daughter?
His daughter.
Was it? Everybody agree? Laura?
Wasn't that the babysitter? The guilty
Yeah, the
plea?
crime.
Well, read from the case. Where is it?
Yeah.
Was it-
The offense was alleged to have occurred. The victim had been a female babysitter for the daughters.
Okay.
And it just says the father seems to say that the evidence was erroneously admitted for the purpose of showing that he sexually abused his own daughters.
His own daughters. And so the court ends up saying is the reason it's admissible is because why? Now remember what we just went over. What's the issue at care and protection case? What does the judge have to
Current
fight?
fitness.
Okay, so what does the SJC say about relevance? Laura?
The then state of mind is admissible if...
No, we're not talking about state of mind. We're talking about, okay, I want to offer in evidence this guilty plea that he did over there, right?
Was it?
And he's objecting and saying, how is that relevant in this case? It's relevant because, why?
It's within, did it have to do that it was within 10 years? I'm thinking back to evidence
You're
class.
making it too much, guys.
We have it?
Yeah, you are. You're thinking about it too much. Nicole?
Is it just because he had assaulted a child and...
Yeah, it goes to his fitness as a parent. It's relevant. That's it. So you can admit criminal convictions in CMP cases. So two different courts, right? Superior Court criminal conviction, and that happened to be not even his child.
No.
Okay. Admissible in this C&P case relative to his own children. Now let's go to the out-of-court statements,
Yep.
Amanda. So first of all, what were the out-of-court statements?
The out-of-court statements were made by the teachers and social workers, psychologists on behalf of what the daughters had said to them.
What else? So was the daughter's statements to...
The judge admitted testimony
No, wait, stop for a second. What else was an out-of-court statement? Besides the daughter saying something.
The daughter's use of the
Anatomically correct dolls. Okay, so we've got the statements. And DSS is, proffering that these statements should come in, right? And the reason why DSS says they should come in is for what? Because they're hearsay, correct? Just to get that clear.
Yeah,
It's
they are.
statements the kids have made. It's demonstrations the kids have made, which are also out of court, right? And so they're going to be offered, what's the definition of hearsay, guys?
Out-of-court statement made by the declarant. Offered for the truth of the
You're all
matter.
saying it. Out-of-court statement offered in evidence.
For the truth of the matter asserted in the statement.
So DSS says, no, it's not that. We know that's inadmissible. We want to put it in for what reason?
Their state of mind.
Their state of mind. Okay, what state of mind mean?
The mental condition regarding the issue that's going on.
Yeah. And usually state of mind can be, a material issue in a care and protection case. What's the kid feeling, thinking, etc. What's the kid's state of mind? So what was wrong with that?
That he substantially relied on the evidence as proof of critical past events, which he anonymously limited to state of mind.
So what does that mean? So in the future, if you're relying on Jennifer, in the petition here, DSS, what do you have to be careful about if you're going to offer out-of-court statements of the kids? How and in what way can you get them in under Jennifer?
Under
Jim? I'm sorry. Go ahead. Amanda, you can answer.
Under Jennifer, and what, the state of mind exception? Wouldn't it be that?
Yes. You have to be careful that if that's all you've got, remember the evidence has to amount to clear and convincing for this trial. If you only have out-of-court statements and you're saying, oh, Judge, I'm only putting them in for state of mind. Judge says, okay, under Jennifer, I can rely on them for state of mind, but I can't use them to support all my findings of fact that the parents are unfit. That's all you've got, right? It can only be used for state of mind. You guys okay with that? Yeah? Yes? Because you're going to be using these cases for your arguments on Tuesday, for your, whatever we're calling what we're doing.
I just have a quick question.
Yeah.
Did they give the child a doll to observe her with the doll to see?
And I'm noticing the assignment that I gave you, Jason and Alicia were given the anatomically correct dolls. It's to help kids to say, this is what happened. Let me show you what happened. Put the doll on top of the other doll, etc. Yes, yeah. And it's a way of, of questioning young kids when there's sexual abuse. Who wants to do custody of Miguel? Nicole.
In custody of Miguel, the father was kind of rough with the mother, and 51A was filed because they were afraid of the emotional, neglect that it would put on the children from seeing all of that. In public, he would be really forceful with the children. He shook his 3-year-old. He would yell that he was gonna, kill them, throw them out a window. So a lot of 51As were filed on him. And then the children and the mother were separated from him. They were living in separate places, and then slowly the teacher started to realize that Miguel was not showing up to school. So they found out he was staying time with his father in his father's house with the siblings. Miguel said he was convinced he would be kidnapped and killed if he went to school. So the court investigator's report, basically, she kind of observed him with the children and kept saying things like clinical observations is what they called him, how, you know, he was obsessive and, you know, he was paranoid and all of these different things. And the father argued that she had no expertise in this area to be able to testify about his mental fitness to parent his children. So, but the court ruled that the court investigator is allowed to make those kinds of observations and put that in the report. So the court intervening in the family was correct.
Why did I give you this case in the middle of all sexual abuse cases?
It covers court investigations.
What's that?
Because it covers court investigators.
And it's court statements of children, right? Besides that, and obviously this follows from Jennifer, a state of mind is admissible, et cetera. And besides the investigator report that Nicole just mentioned, you will see in this case and a lot of others this rationale of parents being unfit because of non-cooperation with the service plan. So, and there's another child named Oscar. What does the court say about Oscar? Laura's shaking her head.
Yeah, I really, it was one of the very few things in 16 cases that I liked, but that you don't need to wait for a disaster to happen and they could pull, because Oscar wasn't demonstrating the same impacts that the three older children were, but that you could still pull Oscar, that you don't need him.
So no evidence of one child being abused, but loss of custody to that child is still okay. And not the SJC, this was an appeals court case, right? Yeah. The appeals court says, quote, a judge does not have to wait for disaster to happen. So you want to also keep that in mind in terms of current parental fitness towards, you know, all of the children. So sort of, it's almost like a totality kind of concept, isn't it? You know how I remember this case? I call it the cake frosting case. I love it. The kids ate cake frosting for lunch. I wouldn't mind eating cake frosting.
Kids didn't see anything wrong with it.
Who wants to take care of protection of mother? Okay, Jen.
Okay, so this case was okay, so the two parents married, then they had 3 daughters. After the third birth of Tammy, which was the third daughter, the father's sexual demands became more. I guess it increased. The mother at this point allowed him to have sexual intercourse with the daughters. The mother took pictures with the father engaging in sexual intercourse with the children. The mother never told the daughter that the actions were wrong. She was kind of encouraging it. The father brought Martha to the hospital on January 11, 1985 because she had high fever and respiratory problems. At that point, that's when the doctor saw bruises and started inquiring about the bruises. He said that he would never abuse his children. At that point, 51A was filed. The father denied abusing the children. Then one of the other daughters, Donna, was brought in. They examined her. They found that she had a vaginal infection, and Martha tested positive for gonorrhea. So at that point, they tested his father for gonorrhea. He came back negative. Then a 51B was filed at that point. On the January 18th, this part was a little fuzzy, but on the 18th, I guess the neighbors found the photos of the children. And at that point, the children were taken away. I think this is pretty much the same thing as the Jennifer case. They used the statements of the children in the trial saying that it was hearsay, but they allowed the statements in. Is that right?
Well, with the statements, when the SJC reviews the case, right? So you've got these hearsay statements of the children, right? With those hearsay statements, the judge allowed those hearsay statements in error. Was it wrong? The judge may make a mistake, basically, allowing the hearsay statements. Just the hearsay statements.
Right.
Yeah.
I would say that
But, go ahead.
I would say that they didn't make an error to let the hearsay statements in because it still explained to the court what happened to the kid.
What evidence did the court have besides the hearsay statements?
They also had the photographs.
Exactly, the photographs, the criminal convictions, all of this other stuff. So there was error, but it was harmless error.
Right.
So the hearsay itself is inadmissible. If even with this serious case, if the court didn't have the other evidence, DSS would not have met its burden. Keep that in mind, because again, if it's hearsay and if it doesn't fall within the exceptions, or even if it falls within the exceptions, it might not be enough to amount to clear and convincing evidence of a fitness. But what the SJC ends up saying is, oh, yeah, fine, that was error, sure, but there was so much other evidence. You had the parents' criminal convictions, you had the photographs, you didn't need really the out-of-court statements of the children or the diary. Okay, that's why it's so important. That's it. Now we're getting into sort of another category. Now we're getting into the cases that construe the statute, Chapter 233, Section 81, Section 82, Section 83, right? 81 being out-of-court statements of children under 10 regarding sexual abuse in criminal cases. So 81 is criminal. 82, your civil, which is really your termination cases, your adoption cases. And then finally, 83 is your care and protection case. So we have the first one here, Collins, Commonwealth versus Collins C. Nicole?
This kind of deals with children being like a witness and how, if they're allowed to do that. An older child built a tree house, two younger children, Ned and forget the other one's name. Anyway, two younger kids, and after building it, they would hang out in the tree house, and the children were then sexually abused in the tree house by him and several of his cousins, the older children. So he ended up taking the rope and the ladder away so that the children were stuck in the tree house, and they basically had to just deal with what they were dealing with at that time. The children didn't come forward right away, and they were seen by a child psychiatrist who was an expert in child abuse cases. And they basically were able to, well, they tried to use the children and what they told their parents and then the psychiatrist and all of that as to see if this child had really molested the younger children as well. And the judge basically says that the children who can tell the difference between a lie and what's right and wrong are allowed to be, sworn in as competent witnesses or whatever. And the children ended up, if you bring in an expert witness, it can kind of bias the jury as to what could have really happened.
Yeah, so what can an expert testify about and what can an expert not
What's in their
testify about?
expertise.
Say that again?
What's in their expertise. Like
Yeah,
what they
so
specialize in.
if this expert had done it right, he or she, I forget who the expert was, would be basically testifying what? Saying what?
That the children display,
Yeah.
tendencies of sexual abuse.
Yeah, so and what couldn't then the expert testify to?
Anything else?
That the child was actually sexually assaulted.
Yeah,
Right.
she
So it
was
goes-
only allowed to say that she thought that they did exhibit those.
Yeah. So now, besides the expert, and this is why we're reading this case, the court goes into the chapter 233, section 81. Do you want to talk about that, Nicole?
Yeah, I have it. Okay, here it is. It says, okay, sorry, I have it highlighted here. Okay, this deals with constitutional issues that the older youth brought up, I'm assuming. Am I wrong? The older child brought up about his constitutional issues.
In what way can the out-of-court statements come in?
Where the child was unavailable as a witness, refusal to testify, or there was corroborative evidence of sexual contact.
And that's the important thing with the criminal, with section 81, right? For the child's out-of-court statements to be admitted under 233-81, you've got to have corroboration. And then the court also mentions, what are the circumstances also that the court, what are sort of the steps that the court should follow? If the district attorney is saying, okay, we want to have, we're going to proffer that we're going to introduce these out-of-court statements of this kid under 10 under 233-81. What does the Commonwealth have to show? What does the Commonwealth have to do?
Well, it can only be used when it's necessary and if the statement is considered reliable.
Yeah, that's what the statute says.
Yeah.
The court also gave some guidance on, how you do it. So, you mentioned Constitution, so that the rights of the defense are also taken into consideration. Laura?
If the child's unavailable, you have to give prior notice that you're going to use the hearsay.
Exactly. So what you're doing as the Commonwealth, you're saying, I'm going to be, I'm going to be going under 233-81. Here's your notice. The Commonwealth has to show during that, so it's a hearing in and of itself. It's a 233-81 hearing, of which, again, as I said before, the defendant is going to get prior notice, and there has to be a separate hearing regarding this reliability factor of the statute. And in this separate hearing, the Commonwealth has to show by preponderance of the evidence a compelling need for, introduction of these out-of-court statements under Section 81. So because it's a criminal case, the court looks very closely, right, at a defendant's rights. And the district, the Commonwealth really has to jump through a lot of hoops in order to get in the out-of-court statements of the kids under 10 under Section 81. So Colin was actually the first case that construed that statute after it was enacted by the legislature. Now we have care and protection of Rebecca, which is under 233-83, which is a care and protection case. Who wants to do that, Jim?
Okay. This case began in December of 1989, and the mother had custody at the time of her twins. The mother was Helen, and the twins were Rebecca and Ruth. And DCYF had taken into custody the twins after allegations of sexual abuse, based not only on the mother's part, but I believe the stepfather as well. Children were removed from the home, and she subsequently appealed based upon her out-of-court statements as well as the statements of the children, and argued that the hearsay should not be admissible in the case. I'm trying to remember so many cases here. And it's fine, the judge found that the mother had engaged in inappropriate sexual touching of Arnold and James. And he based those findings on the totality of evidence, including testimony of experts, the statements of Ruth and Rebecca made to one of the foster parents and the third foster parent prior to their 10th birthday. And the admissibility and probative value of the statements related to the sexual abuse were considered.
Say that again, I'm sorry?
The admissibility and the probative value of the statements related to the sexual abuse were considered. Rebecca and Ruth did not testify, but told the third set of foster parents that Simon had abused them sexually in their mother's presence, that their mother had touched them inappropriately. And those statements were describing acts of sexual misconduct identified by the perpetrator and made before the child's 10th birthday. And those statements were admitted as substantive evidence of the sexual abuse by the mother based on the provisions of Section 83. And then she argued that the admission were not met because the legislation contains an implicit requirement that the judge find a child a declarant on a bill before admitting such evidence. I think she also said the mother informed the judge that she intended to call the children as witnesses, and that it was her position that the children were incompetent. And it's apparent from the transcript that she was requesting a voir dire on the children's competency as a matter of bearing on the reliability of the out-of-court statements.
So before we talk about Section 83 and the out-of-court statements, why does the SJC vacate the care and protection order and remand the case back to the juvenile court?
I'm sorry, can you repeat the question?
Yeah. Why? So what is doesn't the SJC reverse, and what's the reason why?
I know that they reversed. I need to...
What were some of the holes in the case? The sexual abuse case, right? I said, no. Then she says, the lower court was wrong. We're going to send this back down. I remember in light of the first case that we looked at, Eleanor, on the standard of review, right? The findings were clearly erroneous. They didn't amount to clear and convincing evidence. So why not?
Findings in the care and protection case include a finding sexual abuse has occurred must be proved by a fair preponderance of the evidence properly before the judge. A judge's finding must be left undisturbed, absent of showing that they are clearly erroneous.
So what was some of the evidence that kind of like was a little bit muddy in terms of whether in fact these kids were sexually abused or not? Amanda?
Was it that one of the girls had an infection or something down there, and the mother had to apply cream?
Yeah.
And where they're mentally, their capacity, is diminished or whatnot because of the retardation, it could be seen as applying the cream or a sexual behavior.
Yeah, there could have been a medical justification for the abuse. But really, the reason why I'm giving you this case is not that. It's because it actually was also the first case after 23383 was enacted, in which even though the SJC, sent it back down because the court had erred in the finding of sexual abuse, the SJC then gives us language on, how do you conduct and what's the standard for allowing out-of-court statements of children under 10 when it's a care and protection case. So different from Collin and different from 81. If you want to introduce, if you're DSS, DCF, and you want to introduce statements of children in care and protection case, how is that different from if you were the DA in a criminal case? Is the standard the same? It's not. How is it different?
criminal case, isn't it? Reasonable doubt versus a preponderance in a care and protection.
Well, we just read Colin. What's the standard for allowing out-of-court statements of children under 10? Say you have the same case, and you're going to. The Lee case that we're going to discuss on Tuesday, he was criminal prosecuted, and a care and protection case was, started on behalf of his children. Okay? So you have these same out-of-court statements, right? And the DA is seeking in the criminal case to introduce them under 81. DCF is seeking to introduce them in the care and protection case under 83. The standards are different. That's the point. So first of all, what are the standards? And second, why are they different? Who just did Colin? I forgot. Okay, so Nicole, you said that we need cooperation, right?
Yep.
There have to be circumstances demonstrating special guarantee of reliability, necessity. You got to show prior notice to the defendant. There has to be a separate hearing on Section 81, etc. How is 83 different? What is the requirements, or what were the requirements under Rebecca? And Rebecca is following Section 83. Laura, you have your hand up.
Yeah, I think there's two. It said the out-of-court statement must be introduced by the person who the child made the statement to, so that that person can be cross-examined.
Yeah.
And there must be corroborating evidence.
83 says there must be corroborating evidence?
I thought so.
It's 82, isn't it?
I thought you did read it.
Think about the difference again between what's the focus of a care and protection case? What's the focus of a criminal case?
Current fitness.
What's that?
Current fitness versus best interest of the child.
What's what's happening in a criminal case?
Loss of liberty.
Oh, criminal.
Yeah, a defendant is, facing loss of liberty, jail for years and years. Therefore, the protections are really great. Care and protection case, the focus, and you started to say, is on children, right? Okay. So even though parents are losing custody of their children, parents aren't per se criminally prosecuted, and therefore the focus and the need for the out-of-court statements may be greater. Therefore, the procedure may be less formal, right? Even if you look at the language of the statute, when you look at 81 and even 82, they're longer than Section 83. Isn't Section 83 just like a little paragraph?
Yeah.
Right? Really, for Section 83, Your Honor, this is the reason the child's unavailable. The child, I have an expert saying that if the child testifies, she'll be traumatized. Okay? There's the unavailability. And I have the foster parent ready to testify and be subject to cross-examination because that's who the child, told, or the doctor, or the social worker, etc. So very little. Still, the judge still has to be convinced in some way that the statements should come in, but they come in much easier when it's a care and protection case versus a criminal case. You get that? I hope, because you're going to use it on Tuesday, depending on who you represent. Now, Quentin is in the middle. So Colin was the criminal case. Rebecca was the care and protection case. Adoption. Quentin is is where a parent is not only losing custody, right, but termination as well. So you're going to need a little bit more, right?
What did you say for the Quentin case?
Section 23382 is used in what are called civil cases, termination cases, adoption cases, divorce cases. Who wants to go? Everybody has Has Amanda done one yet? No, okay.
All right, so this is being appealed by the parents because they believe the judge's findings are not supported by the evidence taken together, that the judge didn't meet the clear and convincing evidentiary standard necessary to demonstrate the current parental unfitness, and the court affirms their previous decision, saying that they did, their findings were supported by evidence. Even in the absence of the actual evidence of sexual abuse, there was enough other evidence taken all together so that the parental rights should be terminated. And the evidence being the parents maintained an unsafe and unsanitary home. They failed to take steps to correct the conditions. Basically, the mother was uncooperative with any of the plans by DSS also. She didn't cooperate. She lacked the ability to protect the children from the father's harmful conduct.
Okay, get to the adequate statements. Blah, 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 blah. So what becomes the standard? What are the rules for admitting the adequate statements in a case like Quentin, which is a termination of parental rights? And the court actually analogizes this section 82 to section 81, right?
Yep. So section 82 strikes a balance between the parents' due process right to rebut evidence and the state's need to protect the children. Both sections provide that an out-of-court statement may be made by a child under age 10 related to sexual abuse is only admissible if A, a child is unavailable, and B, the judge makes the additional finding that the statement was reliable based on a list of enumerating factors. And then 82 requires the judge to consider the existence of corroborative evidence similar to the requirement we imposed in Collin. So they're referring back to Collin.
So if you take all that, what you just said, and summarize it, what do you need for the adequate statements to come in?
You need corroborative evidence. To go along.
Unavailability, reliability, corroboration, correct?
Yes.
So the court actually interprets 82 very similarly to 81, just because of the fact that section 82 deals with termination cases where the interest of the parents is so much greater, and talks about exactly what you just said. There's still the need to protect children, but the parents' due process rights relative to losing their parental rights is also very high. So that the judge really has to be convinced that, if they're not going to testify, if there's no way, and some of the reasons why they may not testify might be due to trauma, et cetera. The statements, really have to be reliable, and there has to be some corroboration of the statements as well. Now, Tina is an appeals court case that also deals with section 23382 as well. I'll go back around. John, you had started. Do you want to do Tina?
Sure. This is the case where father sexually abused the oldest daughter. There was evidence of unfitness where the there's something about how the eldest daughter has not received, or the father didn't receive counseling to address the issue of his sexual abuse towards his daughter. The father and mother denied the abuse. It was vacated here because it was ruled that the evidence was precluded to contradict prior determination of sexual abuse by the father. Being harmless error was an error, and that the eldest daughter's hearsay statements were admitted in error. This dealt with subsection 82. And it outlined 4 points of 82. That DSS must give prior notice to the parents that it will seek to use such statements. It must show by more than a mere preponderance of evidence a compelling need for the use of such procedure. Any separate hearing regarding the reliability of a child witness's out-of-court statement must be on the record, and a judge's basis for determining reliability must be supported by specific findings, and there should be independently admitted evidence that corroborates the out-of-court statement.
Is there also an in-camera hearing in that case?
Yeah.
What do the appeals court say about that one? In-camera hearing.
Trouble finding it. They objected to the child testifying in camera, and objected to the denial of the mother's request that the judge asked the child about Squiggy and about certain sleeping arrangements, which indicated that the child's memory as to prior events was faulty. So they didn't allow it. They attempted to, well, in the conclusion of the case, the judge vacated it and wanted to use the rape kit, which they originally didn't allow, I guess. So.
What kind of guidance does the appeals court give relative to an in-camera hearing? What is an in-camera hearing?
I'm not sure if, isn't it just them recording child statements?
Anybody know what's an in-camera hearing? Jim?
I'm not 100% sure, but I believe an in-camera hearing is before a judge.
It's before a judge.
And
Yeah,
it's,
it's usually,
closed se-
you know, go ahead.
I'm sorry, it's in a closed session, and the judge hears the, he reviews the testimony or hears the testimony. Not sure if there's any cross-examination involved with it, though. I don't believe that there is. I think that he just hears the testimony from the child. in
Yeah,
an
like
in-camera setting.
an absolute, I don't know how else to put it, a true in-camera hearing originally involved just, you know, really judge and child. Now, the different variations of it, and one thing the appeals court talks about is, yeah, you know, you might have an in-camera hearing again because the child would be, you know, traumatized by the whole court procedure, et cetera. But because parents have such a due process right, at least have counsel for parents there. So there's different variations of, and in-camera hearings have been allowed. It depends on the case, you know, it depends on the court, it depends on the situation, it depends on, you know, how loud people are screaming against it, before it, et cetera. So the appeals court ends up saying, you know, if you're going to have it, maybe you want counsel for the parents present, maybe even allow them to act, you know, to cross-examine, to ask some questions of the child. If you're not going to have anything like that, then, and if you're going to rely substantively on the kid's adequate statements, then the court ends up saying, let's use the same procedures that adoption of Quentin talked about, which were those 4 points that John just made, which related back to Colin. You know, notice, preponderance of the evidence, you need a compelling need, the separate hearing, and corroboration. Adoption of Daisy is the next case, and it's a very recent case, 2012, Nicole.
Daisy was 9 years old when she started telling certain people in her life that her father was sexually abusing her. But the statement she was making was, when she was either 10 or younger, and the main part of the case is, can those be admitted into evidence? And section...
Because she was under 10 when she made them.
Yes, but
and then-
over 10 when they were being admitted
Exactly.
into evidence this trial. And the judge ruled that anytime a child is making any kind of statement about sexual abuse regarding what happened to them, it can be admissible. And they were allowed to bring it into court because she was 11 when it was being brought in
Exactly.
for evidence at trial.
Yeah, it goes to how old you were when you made the statements. That's it. That's Daisy. Marilyn v. Craig, now we have a Supreme Court criminal case. And then we'll get to some of the mass criminal cases. Laura?
This was Supreme Court 1990, and it was really about the confrontation clause. And as we thought about it, right, confrontation clause ensures that it's under oath.
So in what way, so up till now we were dealing with out-of-court statements. So what was the nature of how the court heard this criminal case?
I think it was through one-way closed circuit
Yes, yeah.
television.
Okay.
And so on appeal, the defendant brought up the confrontation clause.
Right.
And so the 4 parts of the confrontation clause is to ensure that it's under oath, the ability to cross-examine, the jury to observe the demeanor of the witness, and physical presence. And what came out of this case was that physical presence, it isn't an absolute, it's a preference, and where necessary to protect a child witness from trauma, the confrontation clause, I wrote down, does not prohibit alternative procedures.
So, but what do you have to show if you're the state?
That the trauma to the child witness from testifying in the...
Yeah, no, like an absolute necessity. You know, even though the face-to-face isn't a federal absolute constitutional requirement, you really got to show necessity for a procedure such as this. Now, somebody talk about Emerald and just sort of, we can take the 2 cases together because that was a huge case in Massachusetts in the mid-1990s and late 80s into the 90s. Anybody give us like a brief history of the Emerald case?
I will.
Let's try. Okay.
This was a case involving a man that worked for a school. I think it was his mother that owned it. Multiple occasions touching children, doing things with them inappropriately, bringing them to the bathroom on the 2nd floor, performing all kinds of acts on them as they were with him. I think...
So when we look at the first case, and I titled it Emerald 1, the 1989 case that went to the SJC.
Oh, yeah.
Tookies, that was,
Yep.
Conviction. What was the doctrine that the SJC talked about in affirming Tookie's conviction? What kind of evidence, for the most part, was did the lower court, did the Superior Court hear?
Was it
against
videotaped evidence of the children?
Wasn't videotaped.
Not videotaped?
A lot of people testified, right?
Yeah, all the parents.
A lot of people testified.
Yeah.
So if they were testifying and they were parents, they were teachers, they obviously didn't see anything.
Yeah.
So it was out
It
of
was
statements,
hearsay,
right?
yeah.
It was hearsay. So how was that allowable? And I'm sorry, there was some video, there was like videotape of like one child or something, but the overwhelming evidence was all of these out-of-court statements. We're gonna get to the Massachusetts latest requirement, but it used to be called fresh complaint. So under Emerald and before, we're going to deal with Avila's, it's one of the later cases that I give you. Before Commonwealth v. King, and I didn't give you that case because it's an adult case that set the standard, the doctrine was called fresh complaint. And what it meant was almost exactly what it said, that in any, not just a child case, in any, criminal, sexual assault, rape type case, that, say the rape victim, went to the police shortly after, so fresh complaint, she was raped. Police officer could take the stand, and technically it would be an out-of-court statement, right? But it's not admitted to prove the truth of the matter. It's admitted for the purpose of letting the court know that the victim complained to this person. And notice that in Amaral, 22, there was a bunch of people that testified. And fresh complaint was sort of that evolved, over a period of time, where courts ended up saying that, fresh, for example, in the Amaral case, fresh complaint could be interpreted as even, like 15 months later, for example, if in the mind of the victim, right, that the victim is still sort of traumatized by the situation, it's still a fresh complaint.
Even
Okay.
if there has been a lapse in time?
Exactly. So let's go to Amaral 2, which is a little bit different. In Amaral 2, the argument has to do with these seating arrangements, right?
Yeah,
That-
was it the children,
Yeah.
if
You
they
want to
should
talk
be
about it,
there?
Amanda?
Is this the one where they had to put a screen in between?
It wasn't a screen, but it was these child-sized tables, etc.
Oh, and they stood a certain way so that the child didn't have to make direct eye contact.
Exactly. So Gerald Tukey was, brought the case back again to the SJC and said, you know what, this violated Article 12, my face-to-face right under the Mass Constitution. SJC says, you know what, there could have been a problem with that, but what did the defense do that was too bad for him? Were his rights violated by these seating arrangements?
I think they were trying to say that they were, but
Exactly.
they weren't. I'm trying to find it, sorry.
So this is years later that he's arguing this.
Because
Right.
they didn't object at the time.
Defendant, SJC says, you know what? Yeah, your rights were violated because Mass gives more rights than the feds, right? So it isn't just Maryland v. Craig where you could have a screen if you can show necessity. Under Mass, Article 12, you know what? You really do need the face-to-face. And these seat arrangements indeed may have violated his rights, but he waived that right, didn't object. And that whole thing also comes from Johnson, right? Face to face. So if you're going to argue that my client, the defendants, has to be able to see, right? If the children are in some way going to be testifying against my client who's going to lose his liberty rights. In Massachusetts, Article 12 says every subject shall have a right to meet the witnesses against him face to face. And age alone is insufficient to show a compelling need. Ultimately, you might be able to show a compelling need, but you have to remember that, again, in Massachusetts, you really, that for the most part, defendants have this confrontation right that's far greater than the federal confrontation right of face-to-face. So there you go, I just gave you Johnson. Bergstrom dealt with the electronic means, the
Sorry,
TV.
Professor.
Yeah.
What would be a compelling need
What would be a compelling need in terms of a kid?
as far as face-to-face in Massachusetts? I mean, when would you argue that?
Think of a child who's been sexually abused by his dad. Think of Alicia and Jason. If they weren't going to testify. Well, or if, say it was Jonathan, who was his 4, in your scenario was 4, right? Let's make him a little bit older, maybe 6 or 7, right? Would that be a compelling need? Really, does dad and his attorney need the face-to-face? Need to be able to ask this 6-year-old questions? Maybe. So you have the face-to-face on the one hand, and you have the child that they say that sometimes the court procedures and what you put the kid through, after might be worse than the abuse itself, right?
More often than not, the children don't testify? Is that what you see a lot, or?
Yeah. But then again, you have to have the evidence, right? You have to have the evidence. We'll skip Bergstrom because it's the same sort of thing, the electronic means, blah, 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 the confrontation right in Massachusetts, because I want to deal with Aviles. And I think that's your last case, yes. And we have like 5 minutes, literally. So I just mentioned fresh complaint. Aviles talks about what the current doctrine in Massachusetts is, its first complaint. Can anybody summarize it really quickly?
I think I can.
You think you can? Okay.
The first complaint means that the complainant and the person that they told can both testify, but the complainant cannot testify about all the other people they told apart from the first
So
one.
what was going on here that would make it clearer?
So this girl, Marie, she had been touched by this man whose apartment they lived in, and he had actually had sexual intercourse with her. They were separate events, and the first time when she told her mother about it, she was crying and hysterical.
When you say she told her mother, what did she tell her mother the first time?
She said that he had touched her,
Yeah,
which was why
and then
she
they
didn't
moved to
want
grandma's.
Yes,
Yeah.
and
And then she sees years later, or whatever it
3
is.
years later,
3 years
yeah.
later, he's on the TV.
And then that's when she told her grandmother, he sexually abused me. And so the mother talked to her about it. So the grandmother told the mother, the mother then took her to the police, and they only let the mother testify about the touching, but they said that the complainant to the grandmother was it was a first complaint of a second abuse.
Okay, so keep in mind, first of all, first complaint means that's it. the person you first complained to. What became tricky with this case, though, is remember that the prosecutor had Marie on the stand and questioning her about her maybe fabricating the story to want to move to grandmother's.
Right.
So while the SGC concluded under first complaint, the Commonwealth would not have been able to present evidence about Marie's disclosure to grandmother. But the admission of that evidence didn't become prejudicial error because it was offered to rebut the defendant's suggestion that, Marie had fabricated her accusations against him.
Because she was already living.
Exactly. So it ended up, it was error, but I'm sorry, it wasn't, in the circumstance of this case, it wasn't error. But if that wasn't the case, she wouldn't have been able to testify. Marie's mother would not be able to, neither would Marie's grandmother, etc. So it's only the first person you're complaining to. And why is that? What's the reason for that?
Because it's like pile on. Like if I told everyone in this room and they all testified.
And they all testify. It's prejudicial when you think about it to a defendant to have, it looks like that makes it true. Like all those teachers testified, those parents, I'm sorry, that testified against the Amaranths. So I'm just going to reiterate what our roles are. So I have DCF attorneys John and Stephanie, Tuesday. District Attorney Jen and Nicole. The investigator is Jim. Mike is the guardian ad litem. Amanda S. is Alicia's attorney. Laura is Jason's attorney. Amanda P. is Jonathan's attorney. And Joe and Jonathan, Lee's attorneys. Okay? So we'll start with that on Tuesday.
So we're gonna come up with our arguments or our...
Yep.